Well, a group of high-profile journalists and activists made their first round of statements yesterday at a U.S. District Court in New York City against the National Defense Authorization Act, also known as NDAA. The group has filed a lawsuit against the Obama administration determined to overturn NDAA. Provisions in this bill, it's a military spending bill, but some of the provisions give the United States military the power to legally detain suspects indefinitely and without charge or trial. And that could include American citizens, as long as they're suspected in some way, shape, or form of being associated with terrorists. Plaintiffs include Pentagon Papers whistleblower Daniel Ellsberg, writer and linguist Noam Chomsky, and journalist Chris Hedges. The lawsuit is named Hedges v. Obama. And I spoke with Chris Hedges earlier this month about the lawsuit.
Moves due process for anybody who is deemed not just a terrorist, but to have contact with these associated forces. That's not a term that's defined, it's nebulous. It's quite a frightening piece of legislation.
And Chris said, in addition, there's nothing that gives exceptions to journalists. And since he personally has done several interviews with groups deemed terrorists, this could impact him and others like him who are simply trying to get a deeper understanding of people whose perspective perhaps the U.S. government doesn't want out there. Raha Wala is an attorney with the Law and Security Program at Human Rights First, and he's here to talk about some of the legal implications here. First of all, Raha, let's talk a little bit about the lawsuit itself. I know from what I understand yesterday was sort of a preliminary thing. They were giving statements about why this is important. I know last week Chris Hedges was questioned by the government for 4 hours to make sure he was deemed a suitable plaintiff in this. Break this down for us, how this works.
Well, I think your introduction to this segment really kind of got at the core issues in this case. Basically, what the law says is that if you are determined to be a member or a substantial supporter of al-Qaeda, the Taliban, or a quote-unquote associated force, the military can hold you indefinitely without charge or trial. What this lawsuit is seeking to challenge is the notion that individuals who may just have a very tenuous connection to terrorist organizations, journalists in this case, or activists, seeking to challenge the law to ensure that it cannot be applied in an overbroad way.
Certainly part of the beef a lot of these people have is the language. I've read through this section, section 1021 and 1022, and there's words and phrases like associated forces. Well, I could be associated with anyone and not even know about it or do it, but not for the same purposes. How do you get around this, or why was this language, do you think, included in the first place?
Well, I think there's a sense that, something needs to be done about terrorism 10 years after 9/11, and so Congress came through and passed what I certainly think is an overbroad bill. It's unfortunate that the president signed it into law.
He signed it into law, by the way, on New Year's Eve, December 31st of 2011. So I think a lot of people weren't really aware that it was even going on, certainly weren't aware when he actually signed the bill and made it into a law.
That's right. And so, we're faced now with these, ill-defined terms that are very broad. The government says that these are only individuals who are fighting alongside al-Qaeda. Well, it's unclear, quite frankly, how broad or how narrow this bill is. I think, the responsible thing for Congress to do would have been to gotten out of the business of indefinite detention when we have a court system that works very well at separating, those who have actually committed crimes from those who are innocent. Yes, it's troubling, and I think that's why you're seeing all this, post-NDAA activity out there trying to really challenge these overbroad claims.
So one of in this lawsuit, Hedges v. Obama, how does it work? I mean, they issued their statements at the court yesterday. What's it going to take to actually get sort of a full-fledged trial here?
Well, it's going to be an uphill battle for this case. One of the problems is that none of these individuals have actually been detained by the military. So there's what's called a standing issue where these plaintiffs are going to have to show that there is some kind of concrete risk that the government is actually going to come forward and detain them. So that is going to be, I think, the hardest hurdle that these plaintiffs are going to have to overcome in showing that this law is, in fact, overbroad. But I think that process is ongoing. We're going to see, additional legal filings where the government and the plaintiffs will basically spar over what this law means, and we'll have to go from there.
And it's really interesting because we're starting to hear, even though a lot of people voted for this, we are starting to hear just in the last few days, the last week, even a lot of Republicans on Capitol Hill here in Washington are starting to say, hey, maybe we should look at some of these provisions. What's going on in Congress? I mean, how is this happening after the bill was already signed?
Well, I think we saw some of that during the debate over the bill. I agree it's a growing opposition, and I think part of it is that folks are actually sitting down and thinking about this issue and the real threats to individual liberty that this bill could pose. And you're right, there are Republicans on the Hill, there are Democrats on the Hill that are proposing legislation right now.
And we did see before, and I should mention, before the bill was signed, Mark Udall came forward with proposed legislation to sort of rework, and it was called the Udall Amendment, to try to take some of the more controversial things out. That's
correct, and Udall had Republican co-sponsors on his bill. In the House, you're seeing an effort by Ranking Member Smith, who's the Democrat on the House Armed Services Committee, who's trying to roll back some of these provisions. Udall has a companion bill in the Senate. So I do think we're going to see some challenges, legislative challenges to these provisions as we move forward. And
just real quick, yesterday after the court period, the court hearing, there was a press conference outside. A lot of people talking about the severity of NDAA. I want to play something really quick that Jennifer Boland said. She's one of the plaintiffs and executive director of Revolution Truth.
None of us feel safe in engaging in the work that we normally do as journalists and activists. Under the NDAA, we actually feel we are in danger.
So do you think that's going to be difficult to prove that they are, in fact, in danger?
It's unclear. Like I had said before, it's an uphill battle. Certainly, the more that the plaintiffs can show that the military does intend to detain them in some way, shape, or form, the better their odds of success in this lawsuit. But I think that, this lawsuit aside, there are broader legislative proposals out there to really kind of challenge the NDAA and its detention provisions, and we should watch those as well.
Certainly good to know, at least, that more people are talking about this, both in the general public sphere and even those lawmakers haven't forgotten about it. Raha Wala, Advocacy Council for Human Rights First. Do appreciate it.
Thank you.